Certainly in about 2002, 2003, the last point where you had a full-blown transition of the top leaders in the Chinese party, there was an atmosphere of quite a lot of hope associated with where legal reform might have been going. Particularly in the late 1990s, Chinese authorities had pursued a range of reforms, professionalizing the judiciary, opening up space for public interest lawyers that many saw as creating some space for legal reform activities going forward. And particularly after the leadership transition, right around the period of the SARS crisis, major public health crisis that took place in China in the spring of 2003, Chinese leaders took steps that seemed to indicate an increasing openness, particularly for legal reform at that point. In the spring of 2003, there had been sort of right about at the point where the SARS crisis had broken out, there had been a sustained burst of activity focused on the custody and repatriation system, which was an administrative detention system used to round up migrant workers who are sort of overstayed their residence permits or had not had proper papers to be in urban areas. There was a particular incident down in Guangzhou, the Sunzhigang incident, in which a migrant worker had been beaten to death at the hands of the local police. This caused a media sensation when newspapers such as the Nanfang Zhoumo, the Southern Weekend, took a real active interest in this case, generated a huge amount of publicity. Particularly at that point, you also had, at the very same time, a number of activist public interest lawyers and law professors who took an interest in the case and began giving media interviews, but also submitted a petition to Central Party authorities challenging the legality and the constitutionality of that particular detention system. Remarkably, Chinese authorities responded, not only because of the legal challenges, but also because of the public interest associated, the media pressure associated with the case, and they annulled the entire system. Many at that point, in the summer and fall of 2003, thought this was sort of the birth of a new era in which public interest lawyers, constitutional challenges, legal challenges might start to push the system forward to become more open. China's not a monolith. There are always people within the system who indicate willingness and sometimes conduct useful reform experiments. However, I think you can definitely say since about 2005, there's been a sustained rollback of many of the earlier signs that people had thought might be hopeful developments for gradual reform in China. Well, I think one of the best ways of deciding or examining how the legal reforms or the legal environment in the 2002-2003 period compares to the environment today is to look at two particular individuals. Think first of Chen Guangcheng, the blind activist who left China earlier this year, came to the U.S. Embassy, and then is now at NYU in New York. Back in 2002 and 2003, he was openly operating. He was having a measure of success in his efforts to represent the victims of local government abuses in Shandong, in his particular town in Shandong province. And then just after 2005, he ends up going to jail. Then he ends up under house arrest, completely illegal house arrest for a number of years. So there's a distinct difference between his ability to operate in 2002, 2003 and the situation 5 or 6 years later. Take another example, Xu Zhiyong, noted legal activist who in the 2003 period had been one of the key individuals attempting to use the media, attempting to use legal challenges to try to overturn the custody and repatriation system. After his success and the success of others like him who were working on these issues in 2003, he became sort of one of the key members starting the organization, the Open Constitution Initiative, which sought to bring similar challenges, which sought to engage in similar activism on a wide range of other issues. In 2009, authorities move in, they shut down the organization on tax charges, and they subject him and others like him to much more heightened pressure and harassment. If you're trying to figure out what the role of the Constitution is in the Chinese system, you have to understand that it's quite different from anything that you would encounter, particularly in the American system. The Chinese Constitution itself is not judiciable. It's not a document that contains legally enforceable rights that the courts, for example, are entitled to enforce. China is a one-party state. The Constitution doesn't hold that weight. At the same time, that document it has expansive language that both people within the party seek to use to sort of indicate their intention to improve the conditions of Chinese citizens and protect a wide range of rights. And precisely because the people at the top of the system seek to use it in that particular way, that means that individuals lower down in the system, or ordinary citizens, also will throw it back in the faces of officials and say, well, you have these words on paper, and you really should be attempting to respect them.